Hi there, and welcome to this recording on GDPR. Now, the General Data Protection Regulation is a regulation that's come out of the European Union, and I'm going to today give a brief overview of what it means for businesses within Europe and also around the world, how we'll be affected by this, and what are some of the most important aspects for understand and changes to the way data is going to be regulated. Now, this is no trivial matter. Information is very, very important. It's important to us as individuals, it's important to companies, it means big dollars for many industries. But this legislation is taking a big step towards protecting information and realizing the value that is within it. The General Data Protection Regulation is a new regulation. Now, this is an overhaul of the Data Protection Directive. This was about a 20-year-old EU protection law. Now, as a directive, it actually required translating into a law in each EU member state. And so there was kind of a patchwork of data protection all across Europe that will be superseded by the GDPR. Now, if you can think about it, the Data Protection Directive, the previous laws, being over 20 years old now, really were ill-equipped to deal with the way data moves around today in the age of the internet. So this is a well-needed update, and it's definitely about time a major power like Europe took these measures. Now, this law was actually passed in April of 2016, and it's nearly 2 years later, in May 25th of 2018, that they will be enforced. So the deadline is May of this year for this to be enforced and for companies to be ready for that. So brace yourselves. GDPR is coming, and there's a lot that's changing. So who does this apply to? Well, in short, any company that's processing the data of subjects who are in the Union, they could be citizens of an EU country, including UK for that matter. This came into effect before Brexit, so this will likely be a law that stands in the UK. Someone who's traveling through Europe or visiting, anyone who is within Europe is affected. And so it's worth mentioning that this does not apply to businesses in Europe, and it applies to any business worldwide that has people within Europe. So yes, if you're in the United States, this applies to you. Now, there's a combination of factors as to what would determine whether a company is actually targeting EU individuals. That might be like giving people the ability to order goods and services in an EU language, or providing payment options in euros or pounds or an EU currency, providing local content, or even giving international friendly services to people in EU countries. These are all things that would cause you to be within the scope of GDPR. It's a different matter as to why I would need to follow this as well, and it's worth mentioning that under the Data Protection Directive, and as it was translated in the UK, fines were up to about £500,000. So fines of that size were kind of standard for breaches of compliance with data law, but now fines are much, much bigger, up to $20 million for top-tier breaches, or 4% of global revenue, whichever's more now. That's global revenue of a parent company. So if you're Google, that's a fine of $3.5 billion. So these fines are substantial. And they've definitely given this law some teeth, and each EU member state will need to appoint a data protection authority, and they will have powers to access premises and give binding orders and administrative fines and suspension of cross-border transfers. So there's lots that they can do, and it's worth noting as well that there will be measures to enforce this internationally. So if you do not have a representative entity in the EU, and you're an American company or Canadian company or in Australia or Asia, let's say, governments are well adjusted to having to enforce law across borders. So the US and Europe have a long-standing relationship of allowing each law enforcement agencies to communicate, in particular between data protection authorities as well. So they will find ways to enforce this across borders. Now, the other thing that not many people are talking about is these guys, the room within GDPR for litigation. GDPR really increases the rights of a data subject in terms of their ability to take civil action. So, initially, people believe that initially there will be an enormous number of legal cases taken by consumers against businesses over the handling of their data. People who realize companies are holding their data that they shouldn't. I mean, there could be any number of class action suits, and those costs, for a class action, those costs could dwarf those 20 million euro fines, or even 4% of revenue. You can imagine, like a Yahoo level breach or Equifax. These kind of breaches could mean substantial litigation penalties. And the companies that are most affected by this, well, there are this terminology that has been introduced. They're called controllers and processors. Now, previously, all companies were kind of seen as a controller of some sort. Now, controllers are generally the companies who decide how and why the data is processed, or they're kind of the company behind the data collection. But a processor is kind of an idea that's more and more around now, where the companies, could be cloud storage or a marketing agency or an email marketing agency, a payroll company. These are all companies that process data on behalf of a controller. So almost every company is a controller. I mean, in as much as they, have data of their employees, but there are many companies that were not covered previously, who are kind of these intermediary companies that process large amounts of data but are not necessarily the ones calling the shots. Now, they are accountable and within scope, and there is need for them to be compliant and for controllers and processors to work together to make sure that they are compliant. Almost every business will be affected in some way across Europe. I mean, the economic toll on this will be enormous in embracing this, and the technology changes that will likely be required to carry out many of the changes. But as well as that, companies whose core business is around data, so many online companies, tech companies, insurance agencies, banks, health companies, there's many kinds of businesses who carry a lot of data, not just technology, that will be deeply affected by this. So I'm just going to go through 5 of the major changes that we see because of GDPR. And I'm going to start with new roles here. The new guy, any company who has their core activities around data, they will need to appoint a DPO, a data protection officer. Now, this doesn't necessarily need to be a lawyer or someone from the compliance department. But they will need to have a legal understanding, and this is generally seen as an executive level position because they need to enforce compliance across the business, understand the data policies a business has in place, and make sure that they as a company are acting responsibly with data and would be willing to front up to an EU data authority if they ever got in trouble. So these guys are going to be in hot demand very soon. Suggestions of 75,000 across Europe in the very near-term future. So it's going to be hard to find these. Sometimes one DPO will work for multiple companies is the likely scenario here. Data types. Now, the GDPR defines personal data a little differently than it's been seen before. For instance, an IP address or a unique mobile identifier. These are now considered personal data, as well as geolocation data. I believe in the US this is not the case, but if US companies are operating in Europe, they will need to deal with this data according to the regulation, around consent and taking care of that data, because these are now considered personal data. Beyond that, there is a new category of data called sensitive personal data. Now, this is subject to additional protections and restrictions, and these are kind of data around racial or ethnic origin, political opinions, religious and philosophical beliefs, trade union membership, even health and sex life and sexual orientation all come under this sensitive data. And on top of that, this biometric data, fingerprints and retina scans and so on, health data also falls in sensitive personal data. So companies will need to tread carefully. There are increased regulations around holding this kind of data. And you had better have good reasons to hold it. I mean, one of the big philosophical changes with GDPR, I mean, previous marketing efforts and companies in technology were on this bend to gather as much data as possible, and we'll figure out what to do with it later. Really, it's about collecting the data that you need and have a justifiable reason. So justifying why you need sensitive personal data will need to be done to show that you have that data for good reason. Consent. Now, this is one of the major points with GDPR. Explicit consent must be obtained. There's, no more vague consent and vague terms. I mean, people would give these ideas like we're just going to improve users' experience, or for marketing purposes, or future research. Those will not meet the criteria for reasons for why data is collected, and it won't be allowed alongside these ideas of consent. So. Consent will need to be an active decision, not just no silence, consent by silence, or anything like that. And then opting out must be just as easy. So it must not cause any sort of negative residual effects. So it's worth understanding as well that GDPR applies to some data that's already been collected. So companies who did not get consent for the data that they hold may need to go out and reestablish that consent. So you may see a lot of emails going out where companies are saying, hey, we have this about you, or we use your data for this, and this reason. Are you okay with that? So it's possible that this will need to be reconfirmed. And companies who, if you hold someone's data and you don't have record of getting their consent, you will need to reobtain that, because you will need to be able to show how you got their data and that people consented to it. And if they didn't, and if you have no record for consent, you will likely need to either delete all that data or go and reobtain consent. Again, so consent is a big change here, and it's certainly altered the way companies are going about this. And of course, companies really need to use data for the purpose it was collected. This kind of is common sense, but right now many companies operate under this idea that they just collect it and figure out what to do with it later. And no more to that approach. This is a very, very different aim for that. Breaches. Now, a data breach, is obviously a breach of security, or an accidental, or a loss of data, or a disclosure of data. Now, under GDPR, companies actually only have a 72-hour deadline, just a couple of days to report data breaches to their relevant authority. Now, this is going to be very difficult for companies to do, and an enormous measure, but this is a requirement. And on top of that, also to report to their users with undue delay, so the legislation is. Now, a data protection authority, upon hearing of a data breach, they may actually go about requiring a company to let all their users know as well. But notifying of these breaches, no more can companies go for several months without disclosing that. It must be swift action. And so companies will need reporting policies, procedures, and breach templates to work within if they want to comply with this very strict. Now, remember, there's a lot riding on this. I mean, if you fail to comply with this 72-hour deadline and it shows that you didn't with no good reason, you could be considering a 20 million euro fine or a 4% of global revenue. I mean, this is serious. There's a lot of teeth to this, and those fines are dissuasive for a reason, and they will be used to make sure people understand how serious data breaches are. Now let's talk about rights. Rights to a phone call, or the new rights that are kind of introduced. Now these are some of the main ones. This so-called or infamous right to erasure, that if a data subject wants to, they can request to be forgotten. If they believe the data is no longer needed for its original purpose, or no lawful basis for holding that data, anyone can kind of reach out to a controller and ask for that. I mean, they can also ask to know what data is held about them as well. And previously, there was an allowance for like a small amount of money, maybe 10 euros, to find out what companies know about you. But under GDPR, people will be able to know what companies know about them, and they are allowed to for free, and I believe within 30 days as well. So and also the right to restrict that processing, to say, okay, you may know that, but I believe the data is wrong, and they could block the processing of personal data as well. So there are a lot more rights just within that, and there are a lot of technical complications with being able to give the true deletion, to be able to delete records from a database. I mean, data backups is going to be very, very difficult, and really, I think under the European, the European authorities, if you can show that you've at least taken measures to try and comply with this, I'm sure people will be judged according to what was feasible at the time. So if it's not feasible to delete everything, due to microfilm backups or something like this, server backups, it's likely that people will be able to just do what they can to try their best to protect people and to delete the data that they hold about them, as well as this idea of data portability. So data subjects have the right to transfer their personal data between controllers. So let's say you are a health insurance provider and you have someone's data. A person can actually require you to give them a copy of their personal data in a structured, commonly used, and machine-readable format that supports reuse. So they can transfer their data from one controller to another. So they could say, I want to move to a new insurance company. Give me everything that you know about me so I can go to a new one. So this is going to have a huge implication for business and the way people move between healthcare providers, banks, insurers. Even think you're everything that Spotify might know about your music choices. You might be able to take that to a rival Spotify, and so the power that was in recorded data sets will start to diminish. And if a company knows a lot about you, it may not give them that much of a competitive advantage in the future. So this is a big business change I think people might underestimate. Profiling seems to be the norm for many companies now, where automated processing of personal data to try and evaluate people and relate them to what they might like or decide on. It's a requirement for data controllers to notify individuals if they're using their data for profiling. So if Google or Facebook, if they're doing this, people have a right, and they really do have the right to know that. So these rights for the individual are very, very significant, and they have huge implications for how companies are going to need to work with data. And lastly, here, I just want to think about what this means for publishers. In some instances, it's just worth considering. I won't go into depth here, but some cases where publishers will often need to reconsider their activity and how they go about this. For a start, reader consent. If you have a set of readers that you hold information on, you may need to consider how you got their personal information, what their interests are, and their email address and contact details. If you've attained that information, you may need to go back and get consent if you don't have proof of that explicit consent. Or if you got consent from a pre-ticked box, it may not stand up under GDPR. Profiling subscribers, trying to gather their interests. It's worth the effort that you go to around gathering data on people and trying to extrapolate things about them that people will need to know and be aware if you're carrying out that activity. Even submissions for contests. If you hold a contest, you will need to be explicit about what you're going to use their data for. So you'll need to say, well, we're collecting your email address because we want to market to you. We want to send you deals and offers. Now that's kind of happening more and more, but it will require explicit communication of what you're going to do with someone's data. And as well, if you think about it, for these categories, people who are subscribers or readers or contest submissions, they will also need a way to be able to come to you and say, hey, I want you to delete my data. And that may incur technical difficulties as well. Newsletter subscriptions, kind of a similar concept there, and as well as remarketing. So if you are employing a marketing agency beyond yourself, or you're working with an entire marketing department, and if you're in the EU, it's very likely that your marketing department is already considering this. But if not, make sure you work with them on this. And if you do carry a lot of data, you may need to introduce some new policies and procedures. and possibly even, employing or hiring a DPO, a data protection officer, to ensure compliance across your organization, because you do not want to be the source of a fine for your company for not working within these constraints. And lastly, account creation. People who are creating accounts and giving over their data. All of these activities really revolve around the people you work with. I would believe as well, for journalists who work with sources and work with people who they want to quote their information, there may be further restrictions there as well. But we start getting into slightly different territory there when we start talking about, the editorial workflow of journalists and using sources as well. Lastly, let me just close with this. I really do believe that this is an opportunity. That this is an opportunity to find an ethical way for us as technology companies, technology providers, to work with people in a way that is, is correct, that is safe, that respects people. And this is more than just a regulation for us to comply with. I think that this is a way of doing business as we all move forward, making sure that people are respected, their wishes are honored, and that individuals do have the right to control and protect themselves, and they can rely on companies to work with them on that. Not only that, I think it could be suggested that this will be a correction to, many companies who in e-commerce and so on who rely on conversion rates. They often achieve exorbitantly high conversion rates, and they're likely to see a correction to this because the user experience of handing over your data and being profiled and giving consent is likely to detract. I mean, any point of friction in the e-commerce process is likely to cause a person, to be less likely to buy, should I say. So there's going to likely be a correction in e-commerce and in lead generation. And I think there is also an opportunity for many technology companies to help businesses with compliance, to do this well, to provide a great user experience for someone to understand what's happening with their data, that they can be worked with, in honesty and integrity, not just obeying the law, but also being respectful. Well, that has been my presentation on the General Data Protection Regulation. I'm Brendan from XWP. If you have any questions, please reach out to us. We'd love to work with you to help you move through GDPR.